Hello again, and welcome back to another edition of the Wiccan Conservative. Today, I just wanted to bring something to you guys' attention. You probably already know that the Emmett Till lynching bill has passed and went into law. Now, if you've been following this channel for a while, when the Jussie Smollett hoax was just breaking, I did a video. Kamala Harris had introduced a bill to the Senate. It is called the Justice for Victims of Lynching Act of 2019. This bill introduced by Senator Kamala Harris at the time. This is Senate Bill 488, the Justice for Victims of Lynching Act of 2019. We talked about this bill, what it was supposed to do, and what exactly its intentions were. It did not go into law, but just briefly, this is a highlight of who introduced this bill, Senator Kamala Harris, and who also co sponsored this bill. As you can see, I've highlighted all the senators' names. In green are my two senators from Georgia at the time, Mr. Perdue and Mr. Isaacson. They also co sponsored this bill. And this bill, to refresh your memory, was an attempt to amend Title 18 in the U.S. States Code to specify lynching as a deprivation of civil rights and for other purposes. So I went ahead and made this super easy for you guys. Chapter 13 deals with your civil rights. As you can see on your screen, it has all the sections on the left-hand side, and on the right-hand side, it tells you what is covered under those sections. So under Section 241, conspiracy against rights, deprivation of rights under the color of law, exclusion of jurors on account of race or color, discrimination against a person wearing uniform of armed forces, federally protected activities, deprivation of relief benefits, damage to religious property, obstruction of persons in the free exercise of religious beliefs, freedom of access to clinic entrances, and hate crime acts. So the bill that Kamala introduced wanted to specifically modify this section of Chapter 13 civil rights, and they wanted to add a whole nother section just on lynching. Now, you're probably asking yourself, well, what's the difference? Because we ended up getting H.R. 55, which was the Emmett Till Anti-Lynching Act. So what exactly did that modify in the law? As you can see, to amend Section 249 of Title 18 United States Code to specify lynching as a hate crime act. So they could not get lynching onto the section that defines what is considered a civil rights violation. So instead, they went ahead and actually modified lynching to fall under a hate crime act. Section 249A of Title 18 United States Code is amended by adding at the end the following. Lynching. Whoever conspires to commit any offense under paragraph 1, 2, or 3 shall, if death or serious bodily injury as defined in section 2246 of this title, results from the offense, be imprisoned for not more than 30 years, fined in accordance with this title, or both. 6. Other conspiracies. Whoever conspires to commit any offense under paragraph 1, 2, or 3 shall, if death or serious bodily injury as defined in section 2246 of this title results from the offense, or if the offense includes kidnapping or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, be imprisoned for not more than 30 years, fined in accordance with this title, or both. So that is the actual statute that went into law under the 249 section of Title 18. So let's go in and actually see it as law because they have updated it. Now, the first thing that I want to show you here is the general definition of offenses under Title Title 18, Chapter 13, Section 249. This is actually the statutes that are written for hate crime acts. Yes, I have this highlighted. Yes, you're reading it right. In general, offenses involving actual or perceived race, color, religion, or natural origin. Whoever, whether or not acting under the color of law, willfully causes bodily injury to any person, or through the use of a firearm, a dangerous weapon, explosive, or incendiary device, attempts to cause bodily injury to any person because of the actual or perceived race, color, religion, or natural origin of any person. So when I first read this, I was a little bit concerned because it says offenses involving actual or perceived race, color, religion, or natural origin. So you can read this one of two ways. So you can have an offense that is actually involving the race, the color, religion, or national origin, or you can have offenses perceived to have involved race, color, religion, or national origin. I keep wanting to say natural. The problem with that is if it is a crime that is done for a perceived racial, color, religious, or national origin reasoning, how do we prove that? How do we prove that? That's a problem. I don't like that word, perceived. Or you can read this as somebody who perceived somebody to be of a certain race, color, religion, or national origin has committed this offense and they were incorrect. So if somebody attacked me in the middle of the night thinking that they were attacking an Asian person per se, it doesn't matter that I wasn't necessarily Asian. You're going to charge them with a hate crime because you think that they were out attempting to hurt Asians. That is also a problem because if you end up attacking me and I'm not Asian just because you thought I was Asian and you thought you were hurting people, I wasn't. So even though you wanted to attack people of a certain ethnicity, didn't accomplish that goal. So therefore you did not commit the hate crime that you wanted to commit. Does anybody else see that this, either way that you read this law, it's perceived as a word that you can't prove? And in a court of law, you're supposed to be guilty beyond reasonable doubt. So when we throw in perceptions into our hate crime codes, this is what we end up with. So let's go down and actually see this in law. As you can see here, under number 5, let me highlight it so that you know where we're reading along here. Number 5. Whoever conspires to commit any offense under paragraphs 1, 2, or 3 shall, if death, serious bodily injury, defined in 2246 of this title code, results from the offense, be imprisoned for not more than 30 years, fined in accordance with this title, or both. So we go back to what I was telling you guys before. So you have a statute of limitations for how long they cannot be incarcerated for in accordance with this offense. And you also have a fine that can be associated with this offense, but there is no restriction on how much you can be fined for, and there's no minimum to the imprisonment. So we basically have an entire hate code statute that is written on perception and ambiguity. This is absolutely not a way to run a country. It's not a smart way to provide boundaries for your citizens. And this opens up the door to expand the criminal justice process. You can tie almost any type of hate to a crime. So this allows the letter of the law to again overreach the actual intent, the actual circumstances, and the actual facts of certain cases for no more than the perception of what their actions were. Not actually what their actions were, what their perception of their actions were, or what people were trying to think that they were doing. I don't know. I really don't like this bill. I didn't like this bill when it was introduced by Kamala Harris. I'm going to go up here and I'm going to show you that these bills are related. And also, they have George Floyd legislation coming. They have Justice for COVID legislation attempting to pass. There's a lot of things that are going to piggyback off of this social justice warrior attitude to building legislation. And the the more narrow our paths become to walk in America, the more inevitable it's going to be to cross that line and go outside of that narrow path that you're allowed to walk. It's going to end up being a problem for all of us. So I just wanted to bring this all to your attention. That's all I have for you guys today. I will catch you on the next one.